This is Ray Brescia with Legal AF, part of the Midas Touch Network. I teach at Albany Law School, but all the opinions offered here are my own. If you like what you hear here and elsewhere on the Midas Touch Network, please like, subscribe, and share to your heart's content. What I want to talk about today is some developments in federal law, or potential developments, where the Trump administration appears to be floating the idea that has been defeated a couple of times in Congress on a sort of moratorium on state laws that would try to rein in and protect consumers from some of the worst abuses of the companies that are developing artificial intelligence. So this executive order draft has been circulating. It's entitled "Eliminating State Law Obstruction on National AI Policy." Right. So the idea basically is to presumably protect AI companies developing AI tools and infrastructure, to protect them from onerous state laws. Read consumer protection laws. Okay, so we'll get into the sort of guts of this draft executive order as we see it. But let's start. Let's go back a little bit and talk about how some of this got started. So in earlier in the year, as Congress was discussing what to put into the budget reconciliation bill that was negotiated earlier in the year, it was floated, and actually this passed in the House. The idea that states could not issue laws affecting companies that were developing artificial intelligence tools. So a complete moratorium on state laws that might rein in abuses from AI companies. Thankfully, that aspect of the bill did not pass through the budget bill in the summer. Recently, we got wind that the House was trying to tuck it back into a defense appropriation bill. It seems like that is off the table for now. So in the wake of those two failures on the legislative front, we've recently heard that reports are that the Trump administration is floating this executive order that would essentially accomplish some of the same things that Congress couldn't get through in legislation, right? And so, it starts out, the draft executive order that is out there starts out with a description of, what federal policy should be to advance the development of, artificial intelligence, and to support companies that are trying to do it, to preserve, American dominance in that field, and that consumer protection laws in states could impair that dominance, if you would, the competitive spirit that that the laws might undermine, right? And so it identifies some disclosure rules that California has, some other laws that Colorado has passed, and then starts with first. After identifying this policy goal of protecting AI companies from state consumer protection laws, it then creates or purports to create an AI litigation task force within the Department of Justice that would go after state laws that, in the Attorney General's judgment, are illegal and contradict current federal law. We'll get into what that might entail in a second. It seeks to cut funding to the states for broadband expansion. It also asks all federal agencies to review all of their discretionary funding and consider cutting funding to states regardless of what its source is, if states engage in conduct and pass consumer protection laws that might be contrary to this policy of promoting American competitiveness in AI. And then it starts to get into a very important sort of legal doctrine of preemption, right? And this is what those congressional efforts tried to do, was to preempt, to prevent states from passing laws that would protect consumers from AI abuses, right? So it starts with first directing that federal agencies conduct a review of the extent to which state consumer protection laws might run contrary to the FTC Act, which is a federal law on consumer protection. Here's the thing. It's very difficult for a state law to run contrary to the FTC Act, simply because the FTC Act says that it does not preempt state laws that go beyond what the FTC Act on unfair deceptive practices prevents. So by the terms of the very statute that the executive order is directing a review regarding, right, the FTC Act doesn't generally prevent or preempt state law. So that's number one. Number two, the executive order directs the federal government to promote legislation that would preempt any consumer laws. So the extent to which the FTC Act might not preempt state laws, which it essentially doesn't do, now the executive order directs the drafting of legislation that would, in fact, preempt state consumer protection laws. And who is supposed to do that? David Sachs, the federal government's so-called special advisor on artificial intelligence and cryptocurrency. So what, taken as a whole, what all of this does, and ultimately what the goal would be to immunize artificial intelligence companies and products from state consumer protection laws. So it's very much a throwback to what's come to be known as Section 230 of the Communications Decency Act, which is what immunizes internet platforms from things like defamation or claims of defamation or using people's images in a way that's not accepted, bullying, things like that, right? So the Communications Decency Act, which insulates those internet companies, is one of the reasons why we get so much AI slop now, that we get misinformation on digital platforms, that there's cyberbullying, that there's revenge porn, all these things that sort of open this Pandora's box, again, all in the name of promoting competitiveness, right? Like not hampering companies by abusive consumer protection regulations, right? So, first and foremost, that's, one of the goals, it would seem, of this executive order, that it would build us, get us towards that kind of world where, just like we have with Section 230, that there would be immunity for AI companies, right? So there are so many problems with all of this. I mean, theoretically, right, the idea that there is a tension between consumer protection and competitiveness is, preposterous, right? Our where American companies remain very competitive, even when we have consumer protection laws, right? That doesn't need to be this sort of a free-for-all, that the companies could do anything they want. And if states had the temerity to try and regulate some of that, those efforts would be prevented and preempted, right? But putting aside whether it's good policy, right? Is this the role of the executive branch, right? To in effect accomplish legislative ends, right, without any direction from Congress, right? This is something we've been talking about for some time with the Supreme Court and the major questions doctrine. I'll come back to that in a second. But first off, right, we have a federal system where states and the federal government, particularly in the area of consumer protection and the use of what are known as police powers, right, have roles to play. You don't force states to follow everything that the federal government does on this, and the rights, right, not expressly granted to the federal government are reserved to the states. And one of those significant rights is the police power and the ability to promote consumer protection, right? And even the very statute that this executive order purports to invoke to allow for this sort of preemption is explicitly drafted so that there isn't preemption, that states can use their police powers to promote consumer protection, right? So we also have problems with the funding aspects of this executive order, right? In the NFIB v. Sebelius case, which protected the Affordable Care Act, right? One aspect of it was that the federal government was using the promotion of Medicaid expansion under the ACA, right? And if states did not expand Medicaid under the ACA, they would lose other Medicaid funding. And although the Supreme Court upheld the ACA in general, that aspect of the ACA was found to be unconstitutional, that, the federal government can condition certain funding on a certain, policy goals tied to that funding, but it can't have this sort of broad-based manipulation of federal funding to achieve policy ends, right? And that was in legislation, not just on an executive order, right? That was on legislation and regulations. It wasn't just an executive order. Okay, so that leads us to the biggest problem with this, right? The major questions doctrine, right? We've seen this discussed in the tariff case that's now pending. We saw this in the Supreme Court striking down the student loan forgiveness program under the Biden administration, right? There is no legislation that exists through which the executive branch could carry out this executive order, right? So the idea that the executive branch on its own could regulate artificial intelligence and, deregulate it really by stripping states of their constitutional police powers to protect consumers, right, is beyond anything that Congress has authorized, and certainly would fall squarely within the major questions doctrine, i.e. that the executive branch doesn't have the authority to regulate in areas where that is a major question, where Congress hasn't given them clear direction to do so. There's no such direction here, and there may be some argument in, and certainly this is something that the Trump administration made with the tariff argument, that major questions doesn't impact foreign policy, right? This is not a foreign policy proposal. This is a domestic proposal squarely aimed at states regulating consumer protection use of artificial intelligence. We don't know if the Trump administration is going to go ahead with this executive order, but certainly, should it do so, I would imagine that almost immediately there would be challenges from state attorneys general, and it might not just be from blue state attorneys general. You likely would see some red state attorneys general jumping in on this kind of litigation as well. So we'll keep tabs on this. We'll see how it develops. But I think that should it come to pass that the Trump administration does go all in on this AI preemption gambit, I think that we're going to see some significant legal challenges to it, and I would think it's safe to assume that those challenges would be successful. Thanks. See you next time.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.